Hey guys, this is attorney Philip Adams with the Law Office of Philip Adams here in Shreveport, Louisiana. I want to spend some time talking to you this afternoon about what it means to actually live in a free society. And specifically, when are you resisting an officer by failing to provide your name? So, when are you required to actually give your name to a law enforcement officer under Louisiana law? Well, we can start by examining Louisiana Revised Statutes 14:108, subsection A and subsection B 1C. These statutes contain language that criminalizes a failure to provide one's name to a law enforcement officer under certain specified conditions. To be found guilty of resisting an officer for failure to provide a name under LARS 14:108, subsection A and subsection B 1C, the government has to prove the essential elements beyond a reasonable doubt. Now, proof beyond a reasonable doubt requires the highest level of proof in our legal system, so close scrutiny has to be paid to any case that involves an alleged failure to give one's name to a law enforcement officer. Cases that fall under 14:108, subsection A and subsection B1C involve wide-ranging implications for the First and Fourth Amendments of the United States Constitution and therefore the rights of citizens of a free state. Let's go to LARS 14:108 and read from it. It states the following in pertinent part. Subsection A says, resisting an officer is the intentional interference with, opposition or resistance to, or obstruction of an individual acting in his official capacity and authorized by law to make a lawful arrest, lawful detention, or seizure of property, or to serve any lawful process or court order when the offender knows or has reason to know that the person arresting, detaining, seizing property, or serving process is acting in his official capacity. Subsection B1 says the phrase obstruction of, as used herein, shall, in addition to its common meaning, signification, and connotation, mean the following. Then we go to C. It says refusal by the arrested or detained party to give his name and make his identity known to the arresting or detaining officer, or providing false information regarding the identity of such party to the officer. Now, analysis of any law that applies to evidence is always guided by a fundamental precept of criminal law. It's a cardinal rule in the law that you cannot be held accountable or subjected to criminal prosecution for any act of commission unless and until that act has first been denounced as a crime in a statute that actually defines the act that is sought to be denounced with such precision that the person who is sought to be held accountable will actually know that his conduct falls within the purview of the act that is intended to be prohibited by and will be subject to the punishment fixed in the statute. Courts have not only consistently refused to usurp legislative prerogatives by supplying either a definition or essential elements that have been omitted in the drafting of a statute, but under rules that call for construction of all criminal and penal statutes, ambiguities are resolved in favor of the accused when it comes to how statutory language is worded. A court cannot either supply a definition, nor may it disregard a clear definition that is supplied by the legislature. So if we look at the wording of LARS 14:108, law enforcement action in the form of a, quote, lawful action, such as an arrest, detention, seizure of property, or service of any lawful process or court order, must occur before, and this is crucial, before any possibility may arise of there being an intentional interference, opposition, or resistance to, or obstruction of an individual who is acting in his official capacity. Detentions and arrests constitute the overwhelming majority of situations that implicate LARS 14:108, subsection A and subsection B1C. So if a detention or arrest is made, then the question arises whether law enforcement officers were making a lawful detention or arrest at the time that the prosecuting authority in a case claims that a defendant intentionally interfered, opposed, resisted, or obstructed the law enforcement officers by not initially providing a name. Any additional details that are learned by law enforcement officers after the time of detention and arrest are legally irrelevant in determining whether reasonable suspicion or probable cause existed at the time of the detention or arrest. So you can't manufacture reasonable suspicion or probable cause in an ex post facto manner. You can't also corroborate reasonable suspicion or probable cause after the fact. To determine whether a detention or arrest of a defendant is lawful, one must carefully examine statutory law and constitutional case precedent in any given case. For an arrest to be lawful under LARS 14:108, probable cause must exist. Now, an arrest is interpreted as any situation in which a person is deprived of his liberty in a significant way or is not otherwise free to go as he pleases. So you don't actually have to be handcuffed to be arrested within the meaning of the law. If you look at cases like State v. Mean, M-E-N-N-E, 380 Southern 2D 14, a case from 1980 from the Louisiana Supreme Court, or State v. Roach, R-O-A-C-H, 322 Southern 2D 222, a case from 1975 from the Louisiana Supreme Court, you can learn more about what it actually means for an arrest to take place. So, for example, if an individual is surrounded by law enforcement officers and told that he is not free to leave, and a reasonable person under the circumstances would believe that that person is not free to leave, then one could argue that that person has been arrested within the meaning of the law, even if no handcuffs have actually been placed on that person. The determination of whether somebody's been subjected to custody is made from the objective standpoint of a reasonable interrogee under the totality of the circumstances. Now, factors to consider in determining if a person is in custody or whether there was probable cause to arrest, whether the investigation had focused on the suspect, whether under the circumstances a reasonable person would have believed that he was in custody, whether the statements and actions of the suspect indicated that he reasonably believed he was in custody, and whether the statements and actions of the officers indicated an intent to restrain the suspect. Alternatively, if the claimed lawful basis for the law enforcement officer requesting a person's name is that that person has been detained, then there has to be reasonable, articulable suspicion that a suspect has committed, is committing, or is about to commit a crime. And you can look at Terry v. Ohio, a U.S. Supreme Court case from 1968, to learn more about this concept of what reasonable suspicion actually means. The determination of reasonable grounds for an investigatory stop or detention does not rest on an officer's subjective beliefs or attitudes. In other words, it doesn't rest on what he personally thinks subjectively. Rather, the determination is dependent on an objective evaluation of all the circumstances that are known to the officer at the time of his challenge action. So in determining whether an officer acted reasonably in circumstances, you have to give due weight not only to an officer's inchoate and unparticularized suspicion or hunches, but you have to look at the specific and reasonable inferences that that officer is entitled to draw from the facts in light of the officer's experience. So for the suspicion to be objectively reasonable, it has to be guided by logic and actual observations. What does this mean? Well, it means that imagination and fear don't equate to objectively reasonable suspicion of a crime. Imagine that somebody might commit a crime without having sufficient corroborating facts makes suspicion unreasonable and subjective. You can't imagine, for example, that somebody might commit a shooting when you see no evidence of any weapons, no gun, no scope, no body armor, no ammunition, hear no threats to commit a shooting, etc., and then call your suspicion objectively reasonable. To avoid being well on our way towards a police state, the law demands a more solid barrier than mere imagination and fear between officers and citizens. So remember, suspicion alone doesn't equate to objectively reasonable, articulable suspicion of a crime that would justify a detention of an individual. In Brown v. Texas, a U.S. Supreme Court case from 1979, that court invalidated a conviction for violating a Terry stop and identify statute on Fourth Amendment grounds. The court ruled in that case that the initial stop wasn't based on specific objective facts establishing reasonable suspicion to believe that the suspect was involved in criminal activity. Absent that factual basis for detaining the defendant in that case, the court held, the risk of, quote, arbitrary and abusive police practices, end quote, was too great and the stop was impermissible. Likewise, in Heibel versus 6th Judicial District Court of Nevada, a 2004 U.S. Supreme Court case, the court held that a statute requiring that suspects disclose their names during a valid Terry stop does not violate the Fourth Amendment if the statute first requires reasonable suspicion of criminal involvement and doesn't violate the Fifth Amendment if there's no allegation that their names could have caused an incrimination. So Heibel basically reaffirmed the holding in Brown. So in summary, if a law enforcement officer requests that you provide your name and identify yourself, you do not have to legally do so unless that law enforcement officer has a lawful basis for requesting your name and identification. So if an officer isn't engaging in a lawful detention, a lawful arrest, a lawful seizure of property, or a lawful service of process or court order, you are safe in refusing to provide your name and identity. Does that mean that a law enforcement officer won't still make an arrest because he or she thinks differently? No. That is always a very real risk that you could encounter in exercising your legal rights under the U.S. Constitution and the Louisiana State Constitution. However, as long as you continue to live in a free society, you are under no legal obligation to satisfy the curiosity of a probing officer who doesn't have a lawful basis for requesting your name and identity. Take care.